Hello friends, most of the times, like if you see in the high courts and the supreme courts, 90% of the councils, I should say, they argue based on the facts, which is totally wrong. Facts are only for the understanding of the higher and higher courts, that is honorable high court or the honorable supreme court, in order to understand what is happening, what has happened in that particular case, so that it will enable them to understand prima facie what is the issue. But basically, if you want to argue in the High Court and Supreme Court, they are not fact-finding courts. They run only on question of law. If there is violation on question of law, that you have to satisfy these courts upon only the question of law and the legally tenable grounds. Then only your petitions will be allowed in these superior courts. So once again, I am telling you, these high courts and supreme courts are not fact-finding courts. So we should not dwell upon the facts. We should dwell upon the question of law, because this is what where if they don't adjudicate the matters, if the high court do not adjudicate the matters based on the question of law, then that particular orders or judgments can be set aside by the Supreme Court, because there is a violation in the question of law. So you need to understand and argue based on the question of law, not on facts and circumstances. Facts and circumstances anyhow will be there, but those also will stand only if there is, strength in the question of law. That is more important. Prima facie there has to be a violation in the question of law. Then only your petitions are maintainable and you will win in your favor if the grounds, the legal grounds or the question of law is in your favor. Not definitely on facts and circumstances. Why? Because what is the fact? As per the Evidence Act, only the trial court is empowered, wherein you will prove the facts in issue as well as the relevant facts. These two things can be proved only by the appreciation of evidence in the trial courts. And once this happens and the judicial order comes out, then the appellate authorities, the higher courts, the High Court and the Supreme Court, can take a call on that. So what you need to understand is the fact-finding courts are only the trial courts, not the High Court and the Supreme Court. So you need to always advance an argument based on the question of law.